First District Court of Appeals now in session. All who have business before this court draw near, give attention, and ye shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Good morning. We have two cases on our OA docket here this morning. The first is case number 20-257. If appellant's counsel is ready, I'll give you the floor. Let us know if you'd like to reserve some time for rebuttal.
Thank you, Judge. Good morning. My name is Kay Simpson, and I represent the Appellate Edgewater Owners Association. I would like to reserve 5 minutes for rebuttal.
Noted.
We are here today based on Edgewater's appeal of the trial court's interpretation and construction of an unambiguous final judgment. The standard of review for this court is de novo. The 2009 final judgment that is at issue in this case was the result of a settlement of two different cases between Walton County and Edgewater, and another case between Walton County and Suzanne Harris, who was the president of the Edgewater Owners Association. The settlement was stipulated to by both parties who were represented by counsel, and in fact, the settlement required the entry of the negotiated language of the final judgment that was entered as a condition to settlement. If that exact judgment had not been entered, there would not have been a settlement of the two cases. The parties agree that the language of the final judgment is unambiguous. It appears that the trial court agreed that the language of the final judgment was unambiguous because there is no mention in the trial court order of any language that the trial court found to be ambiguous. This court has previously ruled multiple times that where the language of a final judgment is plain and unambiguous, there's no room for interpretation or construction of the final judgment, and it must be given the effect determined in light of the plain and literal language used. In this case, despite that principle of law, the trial court did not rely upon the literal language of the final judgment, and instead, as he said in paragraph 9 of the final judgment, the trial court determined that the settlement itself was aimed at Edgewater's desire to manage its own property rather than being subject to the Leave No Trace ordinance. That is at paragraph 9, page 1052 of the record.
So are there places in the final judgment, the 2009 final judgment, that you can point to that will show me that this customary use issue or the exclusion of everybody was contemplated within it?
Yes, Judge. I certainly believe that there is. First of all, the first paragraph of the final judgment is addressed to exactly that premise by defining Edgewater as the exclusive fee simple absolute owner of the beachfront property, defining beachfront property as the private property that lies between the toe of the dune and the erosion control line. That is it was at the time about a 50-foot stretch of sand. There was additional sand between the erosion control line and the mean high water line that was free for the public to use. The paragraph 1 goes on to
I was just going to say, but as I understand it, the county isn't questioning ownership. What we're talking about here is whether the property that Edgewater owns, whether there's some public customary use perhaps that's involved.
They are trying to establish that the public has a right to use the private property. The use of the word exclusive in paragraph 1 as it applies to fee simple property, by definition, exclusive is having the power to exclude and limiting possession, control, or use by a single individual or group. With the addition of the second paragraph, that Edgewater has continuously claimed and asserted that its beachfront property is and has historically at all times been for the exclusive use of Edgewater's owners and guests. The appellee would have you believe that entire paragraph 1 is simply surplusage to the agreement, that it means nothing. But paragraph 9 of the final judgment, page 329 of the record, says, as the terms contained herein, and specifically the terms contained in paragraph 1. It doesn't recite to any other paragraph other than paragraph 1. It says, are specifically and permanently enjoined. The language of paragraph 2 and 3, which says that Edgewater may use its beachfront property, defined as the real property between the toe of the dune and the erosion control line, without interference from the county, means that the county can't try to establish use by the public on Edgewater's beach, because that is an interference with Edgewater's exclusive use, as denoted prior in the order. Now,
that's not necessarily true, right? I mean, even the county within this agreement has Edgewater, under the agreement, there's a 10-foot strip that the county is allowed to traverse.
Yes, and I think that that's provided.
It's a limited thing that wasn't, I guess my issue with the final judgment is that I don't see that it explicitly defines the contours of the exclusivity.
If you look at paragraph 2, what I think paragraph 2 of the order does is prohibit interference whatsoever by the county except as provided herein. So the order does provide what interference and what authority the county has, because paragraph 2 says there's no interference except as provided herein. So the judgment itself lists the things the county is allowed to do. Otherwise, we're left with the fact that they agreed to no interference whatsoever, which means at all. That is the same language that was used in the City of Miami Beach case that prevented the City of Miami Beach from adopting a resolution asserting an interest in the public. And the Supreme Court found that the City of Miami Beach attempting to assert an interest in the public in light of the prior injunction preventing no interference whatsoever was a contempt of the injunction.
Do we know yet whether there is going to be any interference, public type of any interference? As I understand it, the customary use process is ongoing, and from the terms of this, it looks like that the county would be on super thin ice if it would try to say that the public has free reign on Edgewater's property. And so, do we know the nature of the interference, or is that something that is to be determined in another process?
I think we do, to some extent, know the nature of the interference. We know that they have expressed an intent to affirm customary use on Edgewater's property by sending numerous notices. They have filed a lawsuit that says it is their intent to affirm customary use on Edgewater's property. That
but we
is,
don't know what that means yet, do we?
Based upon their complaint, it means that the public are allowed to come onto the property, to set up chairs, to raise umbrellas, to do a number of different activities. As we argued to the trial court, that's a final judgment is also is construed similar to a contract, from the fact that by going forward and saying this is their intent, that is an anticipatory breach. They've said we're going to interfere. They have interfered. They filed a lawsuit against Edgewater. As we said to the trial court, we asked to put on evidence of the current interference that the lawsuit is causing. And the judge refused to allow that evidence. His order does not appear that he reviewed any evidence submitted after the fact on that. And we were not allowed to put on the evidence that showed there was an actual ongoing interference as well as an anticipatory breach of the final judgment. The county has made it plain it's their intent to allow the public to use Edgewater's private beachfront property.
On that, two things. First, the 2009 final judgment, it seems in paragraph 5, contemplates that there's going to be further back and forth between Edgewater and the county because the county is going to legislate at times or pass ordinances, and Edgewater agreed to respectfully examine sort of what that means. And so anyway, it seems like that a situation like this is foreseen within the 2009 order, I think. My second point is that the notice of intent seems to talk about a broader area. It talks about the dry sandy area of the beach from the mean high water line all the way up. And so from what you said earlier, everything dry sandy beach that is seaward of the ECL is that's I would guess permissible, but that's permissible for Walton County to have control of. So we're talking about part of the dry sandy beach being on one side of the ECLL and the other part not being. And so I guess it just isn't clear to me from this notice of intent whether there are any designs on by the county to violate the 2009 judgment.
Well, Judge, those are both good points in connection with paragraph 5 and the requirement that regarding any existing or future provision of the Walton County Code regarding the use of the beach, that Edgewater would examine it and determine whether to adopt it. In the record is after this process was started, is the letter from Edgewater to the county saying that it had considered whether to allow to adopt the customary use provisions and had determined not to. So that was done prior to the hearing. Evidence of that was not taken at the hearing, again, because the judge seemed to feel that any evidence that was admitted was parole evidence as opposed to addressing the issues of contempt of the order. But we have not had a full evidentiary hearing on what was done with respect to that issue. But clearly, paragraph 5 says regarding any existing or future provision of the Walton County Code relating to the use of beachfront property, which is exactly what the Walton County is intending to do. And it says Edgewater gets to decide whether to adopt it or not. And Edgewater did that. The evidence was there and is in the record. And the county proceeded with this lawsuit against Edgewater anyway. We also attempted to put in the deposition of the corporate representative of Walton County, who conceded it was their intent to establish, by the lawsuit, it was their intent to establish the use by the public on Edgewater's property between the toe of the dune and the ECL. So that property, that evidence was available, was actually cited to the court in the deposition testimony, but it does not appear to have been reviewed or analyzed for part of the order. So from that standpoint, we believe that the language is clear and it was error not to afford an evidentiary hearing, as it was noticed as an evidentiary hearing, not to afford an evidentiary hearing on the county's intent and what their intent was, which Mr. Jones, as the county representative, acknowledged was solely the purpose of allowing the public to use Edgewater's property.
Thank you. You're into your rebuttal time, and I'm sorry. I'm responsible for that. Let me add 3 minutes to each side to give you a chance to come back and to give my colleague.
Thank you, Judge. I will reserve my time at this point.
Thank you. Appali?
Good morning, Your Honor. My name is David Theriak, and I represent Walton County. Let me begin with paragraph 9 as well of the trial court's decision. Ms. Simpson accurately quoted the first sentence. The second sentence states that the court finds that there is no other reasonable reading of the judgment, that being that this final judgment pertained to the leave no trace ordinance. When you walk through the final judgment, I respectfully submit that the trial court is correct, that there is no way to construe the final judgment as precluding customary use. Every term in this document relates to the leave no trace. And the leave no trace ordinance was an ordinance that precluded folks from leaving things on the beach overnight. It allowed the county to remove things from the beach that were left overnight. And the lawsuit sought to preclude the county from entering private property. But that's all leave no trace. Now, paragraph 1, the association attempts to read the word exclusive as meaning they have the right to exclude the public. We respectfully disagree. When you read the first sentence of paragraph 1, it says the county does not dispute that Edgewater is the exclusive fee simple absolute owner of the private beachfront real property. Exclusive, we submit in this context, means sole, undivided, absolute. It pertains to ownership. There's no mention in this document of Edgewater's right to exclude members of the public or preclude the historical, customary, recreational use that's the subject of the lawsuit in circuit court. Paragraph 2, well, actually, before I leave paragraph 1, in the briefs, Edgewater attempts to say that the county concedes that they have exclusive use. The second sentence in paragraph 1 is simply an acknowledgement of what Edgewater has claimed. The county doesn't agree with that claim or assertion, but we agree that Edgewater has made that claim or assertion. Paragraph 2, it starts off referring to the association's ability to impose and enforce certain rules of conduct that pertains to leave no trace. And the Edgewater skips over the description of the personal property and the uses that are specifically spelled out in paragraph 2. They jump from as it sees fit without any interference, but leave out including but not limited to maintaining its umbrellas, beach chairs, volleyball nets, coolers, storage boxes, and other beach-related items, and engaging in weddings, gatherings, and other similar events without any interference. It's those uses and the personal property that's at issue that's being left on the beach is what's being addressed in paragraph 2. There's no mention of excluding members of the public or precluding the county from filing a lawsuit to establish customary use on the dry sand that's privately owned by Edgewater. It's pretty clear. The second sentence in paragraph 2 addresses whether Edgewater has to get a permit. And it states that they're not required to obtain any permits for any such uses. Such uses referring to the ones in the sentence that precedes prior. And it also pertains to items of personal property or allowing the leashed pets to traverse Edgewater's property. Again, things that were being regulated by the leave no trace, no mention of customary use. Paragraph 3 allows Edgewater to continue to be exempt from the leave no trace as long as they have rules in place that are as restrictive as the leave no trace ordinance, which is specifically identified in paragraph 3 as ordinance 2008-25. Paragraph 4, again, no mention of customary use. it states that Edgewater doesn't have to obtain a permit, and it details what notice Edgewater has to provide to the county, the sheriff, the fire district, whenever there's a wedding, a gathering, or a similar event of more than 100 people, and it states what the notice has to contain. Again, that
So
is
would it be a problem under this agreement for a member of the public to come onto Edgewater's property and plop down on the volleyball court? What would happen there, or where does that issue an issue like that come into play in this matter or in the customary use matter? Where does that get flushed out?
That issue would get flushed out if the trial court in the customary use lawsuit determines that the evidence establishes the historical recreational use of the dry sand. And then the court can determine what uses have historically occurred on the dry sand. The county, after there's a judicial determination, has the right to adopt an ordinance regarding customary use. There's a contention that the original ordinance is somehow revived. Well, that's wrong. 163.035 states that the ordinance regarding customary use has to be based upon a judicial determination. There was no judicial determination on the first ordinance. It was invalidated by the Florida legislature's adoption of the 163.035 Florida statutes. And there are two cases, federal court, that held that the ordinance is invalid as a result of 163.035, and we cited those in our brief.
Would you agree that it would be a problem that if the upshot of all this is that the public gets free reign on Edgewater's property to plop down on the volleyball court? I mean, from everything we see in our record anyway.
I don't know if customary use would allow the public to plop down on a volleyball court, Your Honor. I think Tonorama is not explicit on how the co-rights of the public and a private property owner are to be implemented. Tonorama, as you know, is the Supreme Court case from, I think it was 1976, that recognized customary use in Florida. It states that there is no ownership right of the public, but there's a co-equal right to use the dry sand, and that each have to essentially respect each other's rights. But Tonorama doesn't get into the weeds on if there's a volleyball court, how do you regulate or allow the public to use the dry sand when there's a volleyball court. And I think that would be something for the trial court to look at when the trial court is looking at whether customary use exists, and if so, what's the scope of that customary use.
Well, and co-equal could get pretty dicey when the county's entered into a stipulation that acknowledges that Edgewater can do all this stuff that presumably the public wouldn't be able to prevent them from carrying out, the volleyball or the beach chairs or the coolers and whatnot.
Well, what the county agreed to is that the county would not regulate those activities and would not regulate the personal property. The county didn't agree that they were abandoning their right to seek customary use. And if this court determines that the final judgment is ambiguous and looks at the record, including the pleadings and the documents that were submitted to the trial court, you'll see executive sessions where the county commissioner specifically stated they would not enter into a settlement agreement if customary use was precluded, if the county hands were tied and could not proceed with customary use. And there's, I think, 3 executive session transcripts in the record, and we provided a list of those at 973 in the record, defendant's motion to strike notice of filing. And in that motion, we identified each provision in the executive sessions where the county commissioner said, we're not entering into agreement if our hands are tied in customary use. Also, if you look at the original complaint, the first amended complaint, you will not find the word customary use anywhere. And while paragraph 19 refers to the right to exclude or seeking the right to exclude, that pertained to Edgewater's objection to the county officials entering their property to remove personal property. There's no allegation regarding customary use. And I would note that Edgewater referred to the second amended complaint. Well, that was never granted. There was a motion for leave to file a second amended complaint. It was attached. there is no order granting the second amended complaint. The operative complaint in this case is the first amended complaint.
Counsel,
you're-
if I could interrupt you just for a second. If I understand your argument correctly, the final judgment is restricted to dealing with personal property. However, would you not concede that there is quite broad language in the final judgment? And if we're looking at semantics and being specific, there are provisions of that final judgment that use the word use without reference specifically to personal property. And each provision doesn't necessarily restrict itself to personal property matters. Do you concede that?
Well, I agree, Your Honor. In paragraph 2, they identify the uses: engaging in weddings, gatherings, and other similar events. And then in the second sentence of paragraph 2, it refers to such uses. So the uses that are at issue in paragraph 2 are separate from the personal property, and they're not going to have to get a permit to conduct those uses. And if you continue through the final judgment, paragraph 6 refers to if the rules aren't being enforced by Edgewater. Again, these rules were a substitute for the leave no trace ordinance. And
Right.
to somehow,
You acknowledge that there is verbiage in the final judgment that refers to Edgewater's quote use of beachfront property and that the county will not interfere.
there is language.
How do you restrict that? Is it your argument you have to look at the document as a whole, and then basically that whole document restricts it only to personal property use despite references to permitting and other matters?
I don't think you can cherry pick words in one paragraph and ignore the document as a whole. In fact, in paragraph 8, the final judgment in parens says at all times a pathway no less than 10 feet in width shall exist between any fixed structure on the beachfront property, paren, including the volleyball net, which is the subject of the underlying litigation. So the parties agreed in the final judgment what the subject was, and that's the volleyball net. And that's because the volleyball net was being left overnight, erected on the property, and the leave no trace ordinance precluded that. To skip over and take use and ignore the 3 lines of personal property and uses that are described and pick up without interference is ignoring the paragraph as a whole. It's cherry picking words, and you won't find anything in this final judgment that remotely refers to prohibiting the county from asking a court to affirm the long-standing recreational customary use of the dry sand in Walton County's beaches as well, which includes Edgewater. It's just simply not there.
Counsel, let me interrupt you for a second. So let's say we assume that we read this as a whole and it deals with personal property. Okay, so it deals with beach chairs and umbrellas and coolers and volleyball nets, et cetera, personal property on this beachfront property. If we're reading it as a whole and assuming that that's the case, and we look at the language in paragraph 1 that says that it is and has historically at all times been for the exclusive use of Edgewater, would we not conclude that it has been for the exclusive use of Edgewater for things like beach chairs and umbrellas and volleyball nets? That is the kind of normal customary use that people engage in on the beach. Isn't that in conflict with your position now that the public is allowed to do, as I think you said, put beach chairs and do those sorts of things through customary use, when at the same time it says it's for the exclusive use of Edgewater?
Your Honor, I disagree. Paragraph 1 does not say that the property has historically at all times been for the exclusive use. It says Edgewater has claimed and asserted. The county did not agree. There's no sentence in here that states that the county agrees with that claim or assertion. We agree that Edgewater made that claim.
You agree to, you have a final judgment that sets forth the terms. It includes a provision that says that Edgewater has continuously claimed and asserted and has historically at all times had the exclusive use of this property. But you don't think that that provision is binding?
It's binding that they have made that assertion. It's not binding that that is a fact that the parties agreed to in this final judgment. The fact that's agreed to is that they made the claim and they have asserted, but there is no agreement in this final judgment. Again, this was a stipulated final judgment. This was not a judgment that a court entered after conducting a hearing. This is what the parties agreed to put in the final judgment in order to mutually settle the case. And this sentence was included to demonstrate that Edgewater has made this claim. County agrees they've made that claim, but that claim doesn't, the fact that it's that sentence is in the first paragraph doesn't make that claim true, just that they made the claim.
And I think at this point, are you necessarily contesting that that will be the case? I mean, the upshot of the customary use litigation could be that the county makes no claims on behalf of the public on Edgewater's for Edgewater's property. Is that correct, or is that
that is absolutely correct, Your Honor. Where we are right now is when the legislature adopted 163.035, they created a procedure for a local government to ask a circuit court to review the evidence that was presented during a county commission meeting. And in this case, there were thousands of pages of documents, and the court will conduct a de novo trial to determine whether the evidence establishes historical customary use on dry sand. It may decide that Edgewater, the evidence does not support Edgewater's, a determination on Edgewater's property, in which case the county could not adopt an ordinance that would address Edgewater's property. Or the court could make a determination that it does. The county still has the legislative discretion to decide whether or not, after the court makes that determination, to adopt an ordinance. It is speculative to state what the court's going to do, and it's speculative to state what the county is going to do after the court takes certain action. So we simply don't know whether customary use will be determined on Edgewater's property. We don't know whether the county commission will adopt an ordinance regulating customary use on Edgewater's property. We don't know what the scope of those uses may be. There may be an ordinance that states you can't park yourself down in a volleyball court. But those are things we don't know at this juncture because it's premature. We're still going through the customary use litigation that the legislature created. So we would ask this court to affirm the trial court's determination that the county did not act in contempt by adopting a customary use ordinance, which was subsequently voided, and did not act in contempt by processing and filing a lawsuit regarding customary use, and again, uphold the trial court's decision. If there are no other questions, I'm down to 18 seconds. Thank you.
Thank you, counsel. And I'll turn it back over to Ms. Simpson for rebuttal. As part of that, I'd be interested to hear your response to whether this issue in this case would be premature and speculative, because the county may not make any claims on behalf of the public as to Edgewater's land whatsoever, is what I just heard.
Okay, Judge, I don't believe that that is speculative. First of all, we know the county has already enacted an ordinance, the 2017 ordinance, which they applied to Edgewater's property. There was no exceptions for that, and it allowed the public to come and use Edgewater's property. So that has they already intended that act, and they did it. It was only because the legislature came in and said, before you can adopt such an ordinance or keep it in effect, you're going to have to go through this judicial process. At that point in time, despite Edgewater's protests that our property should not be subject to the lawsuit or customary use ordinance, and that it was prohibited by the terms of the final judgment, the county proceeded to name Edgewater's property. It is specifically named in the complaint for declaration of recreational use. That is the name of the complaint. It is a complaint for declaration of recreational customary use on Edgewater's property. So they are taking actions which interfere with Edgewater's use of its property. And we had testimony prepared for the hearing as to what those current interferences are by taking the action to try to establish customary use on Edgewater's property, including the fact that Edgewater can no longer get the sheriff's department to take off trespassers or homeless people sleeping on the beach, because they say it is not, they are not sure that it is Edgewater's private beachfront property because of the because of the current lawsuit.
Counsel, if I can ask just one last question. So do you see any distinction between final judgment that seems to deal with the county's ability to regulate Edgewater's use and an action for the public's, a determination about the public's use of property? Meaning, is there some distinction between a regulatory scheme versus a declaration of the people's right to use the beach?
Judge, I believe that if the public has a right to use Edgewater's beach, that the public could seek to enforce that right, and we'd be talking about a different action. Here, where the county is prohibited from interfering with the use of Edgewater's beach, and they've done that by instituting a lawsuit.
You're muted.
Your microphone just muted.
I'm sorry, I think that it comes pretty squarely under the Supreme Court's decision in City of Miami Beach that by the city adopting a resolution that the public could use the property, that was a violation of the injunction prohibiting interference whatsoever with the use of the property. If I could respond briefly to Mr. Theriak's argument, very briefly, the beach rules referred to in paragraph 2 of the final judgment are Edgewater's beach rules. If we had been allowed to present evidence at the time, Edgewater's beach rules said that Edgewater Beach Condominium strictly enforces all rules of our private beach. Each guest of Edgewater must have a wristband, and no one who is not a guest of Edgewater can use the beach. So the rules that are referred to in paragraph 2 that the county stipulated could be enacted by Edgewater at the time provided for the exclusion of members of the public. And paragraphs 2 and 3 both say Edgewater may use its beachfront property without interference. We submit that it's clear interference here, and we would ask that it be remanded to the court. If this court finds that the judgment is ambiguous, we would request an evidentiary hearing on that issue, as well as the elements of contempt.
Thank you, Ms. Simpson, and thank you, counsel. We'll conclude our first argument of the day. We'll take a short recess to reconstitute the panel and get the technology set up, and be back for the second argument. Thank you.
Thank you.
Thank you.
Thank you.
Good morning. It looks like we're set to go here for the second argument, which is case number 20-1492, Black Knight Serving Technologies versus PennyMac Loan Services. If appellant's counsel is ready, you have the floor. Let us know how much time you might want for rebuttal.
Thank you, Your Honor. May it please the court. I'm Graham Allen with Rogers Towers in Jacksonville, representing the appellant Black Knight Serving Technologies LLC, who we'll refer to as Black Knight LLC. If I may, I would like to reserve 5 minutes of my time for rebuttal. With me in the room here is my partner, Christy Russell, who is also on the brief. We are respectfully asking this court to reverse the order of the trial court compelling arbitration on the ground that the appellee, PennyMac Loan Services LLC, waived the right to arbitrate. And as the court seen from the brief, just about a year ago, Black Knight LLC filed suit in state court in Jacksonville, where Black Knight is based, against PennyMac, alleging that PennyMac had misappropriated Black Knight LLC's trade secrets. The suit was based on a master agreement in place between Black Knight LLC and PennyMac, and only between those two parties, by which, among other things, PennyMac had licensed the right to use Black Knight LLC's proprietary mortgage servicing package, which is referenced as MSP, and you will see MSP throughout the pleadings, throughout the documents. PennyMac was served with process the same day the suit was filed. The very next day, PennyMac filed its own lawsuit in federal court in Los Angeles, where PennyMac is based, alleging antitrust violations. This case was filed against Black Knight Inc., which is the parent of Black Knight LLC and which is not a party to the master agreement, and 10 John Doe defendants. And in the complaint, PennyMac alleges that the John Doe defendants are guilty of the same acts and omissions as was Black Knight Inc.
Now, Mr. Allen.
So anytime.
So kind of
Yes,
a
ma'am.
big picture question. How can the litigation against Black Knight Inc., the parent company, who's a non-party to the master agreement, waive the arbitration right under the master agreement?
Because Black Knight LLC, the party to the master agreement, is undisputably one of the John Doe defendants in the antitrust action against Black Knight Inc. and the 10 Does. The federal antitrust action alleges multiple contract provisions that support the antitrust claims, but they never identify a contract. The antitrust action includes 55 references to MSP, that is Black Knight LLC's proprietary mortgage servicing package that Black Knight has access to under the master agreement, but they never identify the master agreement. They never identify Black Knight LLC other than as a John Doe defendant.
Well, is that in the nature of a fact question? Because as I read the order that's on appeal here, it reached its conclusion based on the fact that the lawsuit in California was filed against, it's a separate lawsuit against a different entity, it says. It doesn't say that it was filed against the same entities.
That wasn't a finding of fact. That there was absolutely no finding of fact by the trial court here, and there were no facts in dispute for the trial court to find. That was a determination the trial court made as a matter of law based on the undisputed facts. And it was an erroneous determination based not only upon the allegations in the federal antitrust action, as the federal court in Los Angeles noted when they transferred venue to Florida under the master agreement. The federal judge in California noted, comparing the master agreement to the PennyMac's federal antitrust case, that the case was grounded on the master agreement and was directed to Black Knight LLC. And if there was ever a question, it was resolved after the trial court entered its order compelling arbitration, and PennyMac dismissed the federal antitrust action refiled that exact same action in arbitration. And by that, I mean they took the antitrust complaint directed to Black Knight LLC and the 10 Doe defendants, attached it to an American Arbitration Association arbitration demand, added to that a copy of the master agreement between PennyMac and Black Knight LLC, which provides the authority for arbitration, and filed it in arbitration. And with that, Black Knight was acknowledging that A, it was suing under the master agreement, otherwise it couldn't have brought the case in arbitration, and B, that the primary defendant was Black Knight LLC, which was the only other party to the master agreement. It's three ways the court can make that determination and determine the trial court was in error in finding these were different parties. One is to do the exercise the California federal court did and compare the PennyMac antitrust complaint with the master agreement and determine that's what it arose under. Two is just to look at the California federal court's analysis, which lays it out. But three, and the easiest determination, is to look at the arbitration that PennyMac filed, in which it attached the very same federal antitrust action to the demand for arbitration, filed it in arbitration pursuant to the master agreement, thus acknowledging beyond doubt that the suit was brought under the master agreement. And that
Do you think there's a danger for us in reading too much into what the district court in California did, because it was interpreting a forum or venue provision that was broader than the arbitration provision here?
Yeah,
what I mean is there, I think it said arising under or related to or something like that. But here, our arbitration agreement is a narrow arbitration agreement that just says arising under.
Yes, it was a different standard, and that decision is certainly not binding on this court. It wasn't a final decision in any event, but it laid out the exercise of comparing the California action with the master agreement. And the key is that it was grounded on the master agreement. But any question was resolved when PennyMac actually filed that claim in arbitration under the master agreement. The claims couldn't, the only way they can arbitrate those claims is if they arose under the master agreement. At that point, there was no question. And at that point, Black Knight moved the trial court for reconsideration. We were still within the 30-day appeal period, and the trial court denied the motion for reconsideration. And of course, both the order compelling arbitration and the order denying the motion for reconsideration are before this court. But the undisputed facts are the federal action and the trade secrets action arose under the same contract, the master agreement. Otherwise, it wouldn't be an arbitration today. Number two, the primary defendant was Black Knight LLC, which was the only other party to the master agreement. Otherwise, it wouldn't be an arbitration today. And as well as the fact that the allegations in the federal antitrust complaint clearly go to Black Knight LLC, not Black Knight Inc. And number three, that in filing that case first in federal court, PennyMac filed a lawsuit on an arbitrable issue, which the Florida courts tell us is absolutely inconsistent with the right to arbitrate. So no, the court doesn't have to place any reliance on the federal action other than to use it as maybe a guide to work your way through the federal complaint and the master agreement. But if there's any question, it's determined by the fact that PennyMac ultimately filed that exact same complaint in arbitration under the master agreement, which was a contract between PennyMac and Black Knight LLC only. And the Florida courts tell us that filing suit on a case that arises with the same parties arising under the same agreement is a waiver of the arbitration right. And
counsel, the question with regard to waiver is about whether or not there's a voluntary and intentional relinquishment of the right to arbitrate, right? Is that
exactly?
Do you agree?
I do.
Okay. So let me ask you this. I understand your argument to be that PennyMac very carefully drafts their pleading in the California federal court action, so as to avoid reference to the master agreement, and by way of that, the arbitration issues potentially, right? So my question is, can we say that a party who so carefully drafts a pleading to avoid waiver of arbitration has voluntarily and intentionally relinquished a right to arbitrate? Meaning, aren't those things sort of inconsistent with one another?
No, Your Honor, for a couple of reasons. Number one, the reason they artfully drafted the pleading was to avoid the Jackson, Florida venue clause, I would suggest to the court. But regardless, artful pleading in order to avoid an arbitration waiver by basically pleading your way around the actual contract you're suing on would, I mean, they certainly may have tried to avoid waiving arbitration, but the question is, do the courts of law allow them to be successful in doing so simply by artful pleading and by pleading around the real contract at issue? So that they waived arbitration when they filed the federal action arising out of the same contract. They may have tried to artful pleading to avoid it, but the law does not allow them to do that. And
right. So then we can say that they voluntarily and intentionally waived a right to arbitration while at the same time trying carefully not to waive a right to arbitration.
We can say that exact thing, Your Honor, and that is because the complaint itself, as the California court noted, and as PennyMac has now acknowledged, was based on the master agreement, or arose under the master agreement, which contained the arbitration clause, and was against Black Knight LLC. Courts do not condone artful pleading. They may have tried to plead their way around it, but they voluntarily filed that lawsuit. They voluntarily filed that lawsuit that arose under the master agreement. They voluntarily filed that lawsuit as to which the primary defendant was Black Knight LLC. And they may have intended to sneak around the technicalities and not waive it, but what they did was a waiver. The only way they avoid it is because they carefully avoided pleading the facts that we now know existed.
Mr. Allen, you're a couple minutes in your rebuttal time. Feel free to continue or to reserve your time.
I'll reserve the rest of the time, Your Honor.
Thank you. Appellee's counsel.
Thank you, Your Honor. Lawrence Silverman from Ackerman LLP on behalf of PennyMac Loan Services LLC. Thank you for hearing us today. As the court is aware, Judge Norton found no waiver and compelled arbitration. That finding is supported by competent, substantial evidence and should be affirmed. All doubt must be construed in favor of enforcement of arbitration, and all doubt must be construed against waiver. Case law provides both of those items, and that's an item of federal law under the Moises Hospital case that waiver should, is a difficult burden to overcome. In this case, it's more difficult because it requires a knowing waiver. And as the court has noted, there was no knowing waiver here. There was intentionally not a knowing waiver. Now, the aspersions that were cast that this complaint was specifically drafted to avoid or dance around arbitration or form a non-convenience in the forum selection clause, is incorrect. The complaint as set forth and as a matter of record is against the parent only. And there are very good reasons for that. Number one, if you look at the complaint, it's a Section 2 Sherman Act monopolization case. It's the equivalent of an in re Google or an in re Microsoft. It's not in re Google and 78 subsidiaries. It's against the parent. And in this case, that's important because the complaint specifically relies upon statements made by the parent in its SEC filings regarding market share, regarding the definition of the market. That's the monopolization case. Now, they may be using one or more of the subsidiaries to facilitate that, but it's a claim against the parent. At the time that the antitrust complaint was filed, PennyMac could not have filed that in arbitration. It doesn't have an arbitration agreement with Black Knight Inc. It only has the master agreement, as the court has noted. It was not until the parent corporation stood up in in California and said, we want the benefit of that contract, that PennyMac was in fact able to assert the claims against them in arbitration, and it did so. At all points, PennyMac has taken the position that the arbitration clause is enforceable, and its prior claims against an entity with which it did not have an arbitration agreement cannot constitute a waiver. In the briefs, we have cited, for instance, the 10th Circuit's decision in Cox, which specifically notes under arbitration law, the FAA, Federal Arbitration Act, which is also binding on state courts, that there are no cases in which litigation against a different entity can constitute waiver of the arbitration rights against another entity.
Now, counsel, is there competent substantial evidence here that the Florida Black Knight plaintiff wasn't sued as a defendant in the California action? As I understand your brother's argument here, it's that the Florida Black Knight plaintiff was one of the does there.
Okay, well,
and if it is,
this is not. All right. Well, none of the does are named. None of the does are served. That's a future amendment. This is not Minority Report, where we can predict what's going to happen in the future and prosecute on it now. The complaint, and again, as set forth in Judge Klausner's opinion, this is not a case in which Black Knight Inc., when it was seeking to enforce the forum selection clause, wasn't claiming that it was an intended third-party beneficiary. It was moving under, and the court recognized that its ability to adopt the contract for forum selection purposes was based on a specific judicially created doctrine out in the Ninth Circuit, that if you are a defendant and have a related claim to a claim in which somebody else has a forum selection clause, then we will give you the benefit of that. If you look at the underlying decision in the federal court, that's the basis. They never found privity. They never found any of those items. The reason that we are able to then bring the claims in arbitration after that decision is essentially, there's lots of case law on equitable estoppel, that if you assert claims under a contract, you then bear the burdens under that contract. But there is nothing in the record that indicates that Black Knight Servicing LLC is a defendant, or is quote secretly named as one of the does. The does are future defendants, and they're not defined in any way. But ultimately, Judge Norton, this issue was really clear and well packaged for Judge Norton, which is, are there any cases out there in which litigation against a different entity can constitute a waiver? None were provided below, none were provided on appeal. And again, the single best case on that is the Cox opinion out of the 10th Circuit. Obviously, there's no substantial activity in this case, in the Florida case below or on appeal, that would constitute a waiver. The first thing that happened in the federal case, in the Jacksonville case, was the motion to compel arbitration. That's the only action that was taken. It was noted in the reply brief before that motion to compel arbitration. It was noted by PennyMac that, in fact, if the order was granted, PennyMac would seek to bring its antitrust claims against Black Knight Inc. as part of that arbitration for efficiency purposes. And
now, I was just going to ask, is that a concession that those claims do arise under the master agreement?
No, I mean, it's a concession that since Black Knight Inc. took the position that that it had the benefit of the form selection clause, then we would take the position that Black Knight Inc. was therefore adopting the agreement. It's not clear whether is it covered under the direct answer to your question. Are the direct antitrust claims covered under the arbitration clause? You get to it backwards, which is that there will be antitrust affirmative defenses and counterclaims to Black Knight servicing, the LLC's claims in arbitration, and the antitrust claims against the parent are related to those claims. They're not identical, as noted in the Black Knight Inc. antitrust complaint. There are lots of allegations concerning what Black Knight Inc. said in its SEC filings. Judge Klausner found that some of the claims could be attributed to the MSP, but he never said all of them. They're not identical. But by virtue of the fact that there are certain potential affirmative defenses and things like that, we believe that at that point, the antitrust claim against the Inc. is covered under the constraints of the arbitration clause in the master agreement. So waiver, the question of whether a claim filed against a different entity constitutes a waiver is the primary issue that is before this court. The secondary issue is, if it were, as the court had noted, is an attempt to plead around it, which we don't think we did, but is, if you take the plaintiff's position at face value, which is that complaint was done in an attempt to not waive the arbitration clause, and it's unsuccessful, does that constitute a waiver of the arbitration clause? And there's no case law that supports that either. The case is in terms of waiver is a factual issue. And again, the cases recognize that. And in this case, the judge found that there was no knowing waiver based on weighing those circumstances. The same question that Your Honor's asked, which is, if I've got that scenario, does that constitute a knowing waiver? While there's no evidentiary hearing below, you're not taking live testimony, someone still has to weigh that issue and make a factual determination. That factual determination has a presumption of correctness. And in the arbitration context and in the waiver context, there is a presumption that there's a substantial burden on the non-movement to prove waiver, and that the presumption is that there is not a waiver. And for those reasons, we believe that Judge Norton's decision below should be affirmed. And if they have any questions, otherwise I'll conclude my presentation.
Thank you, counsel. Mr. Allen, rebuttal.
Thank you, Your Honor. Very tellingly, Mr. Silverman never explained to the court how PennyMac could file this exact same federal antitrust action in arbitration based on the arbitration provision in the master agreement between PennyMac and Black Knight LLC, and only between PennyMac and Black Knight LLC, and still say they're not suing under the master agreement, and still say Black Knight LLC is not one of the Doe defendants, that it just does not compute. And basically what PennyMac is arguing to the court is that PennyMac can use nefarious means and artful pleading to disguise who it is really suing in the contract it was really suing under, in order to avoid being tagged with an arbitration waiver. Here, they filed a suit that we know arose under the master agreement because they filed it in arbitration on that basis, the exact same claim. We know it was filed against Black Knight LLC because that is the only party to the master agreement other party of the master agreement that they filed in arbitration. And we know they involved exactly the same claims that were pending in the trade secrets action. You can't file suit against the same party arising under the same agreement with an arbitration clause and not waive the right to arbitrate, which is exactly what they've done. And as far as the Doe defendants, this is not a personal injury case where you don't know the identity of the party that rear-ended you and took off. I mean, they know who they're dealing with. They know who they have a contract with. The only reason to name the Does is because they didn't want to name Black Knight LLC because they didn't want to get tagged with the provisions in the master agreement, even though the master agreement is featured indirectly in veiled references throughout that entire complaint. They even allege that one of the antitrust violations is that Black Knight Inc. and the Doe defendants accused PennyMac of misappropriating their trade secrets and used this as a cudgel to force PennyMac to purchase Black Knight's services. In essence, they have taken the entire trade secrets action and incorporated it in their complaint as an antitrust violation, and then turn around and say that Black Knight LLC, who has filed a suit against them for misappropriation of trade secrets, is not a Doe defendant and is not in the case. If Black Knight LLC is a Doe defendant, there's no question they've filed suit under the master agreement. If Black Knight LLC is a Doe defendant, they have waived the right to arbitrate the trade secrets case. And if the court allows them to prevail on an argument that they intentionally disguise the name of the defendant in order to avoid arbitration waiver, and that this is, for this reason, it's not a knowing waiver, then the court would be countenancing all sorts of artful pleading and nefarious pleading in order to avoid arbitration. And that is not what the law is. When they file the suit arising out of the same claims, arising from the same contract against the same party, they waived the right to force arbitration in the trade secrets case.
Thank you, Mr. Allen. Thank you, Mr. Silverman. This is our final argument this morning. And so with that, we are adjourned.
Thank you.
Thank you.